Welcome to the Binary Agora. I am your host, Alba Rivera Martinez, and on the channel, we mainly address the substantial aspects relating to digital regulation. However, the European Commission is now engaged in a real reconfiguration of its digital rules more broadly, under the premise of streamlining and also simplifying Europe's digital rulebook through the digital omnibus. And to discuss about the real nature about the digital omnibus, I have with me one of the most vocal adversaries to the European Commission's digital strategy in this particular instance, Itxaso Domínguez de Olazábal. She's a policy advisor at European Digital Rights and lectures in both Sciences Po and University Carlos III of Madrid. So welcome to the Agora, Itxaso.
Thanks so much for having me. I'm really excited for the discussion.
So getting straight into the conversation, the Commission calls the digital omnibus as a simplification effort, and you have, in response to that, called it the most ambitious deregulatory move the EU has attempted in the digital sphere. So where do you believe that you fundamentally disagree with the European Commission? How do you explain this disconnect?
I'm going to try to simplify it. First, something that I wanted to say is that simplification in itself is a perfectly legitimate objective, right? Digital regulation, and you know that as well, has become increasingly complex over the last decade, with an increasing number of laws, with the enforcement of such laws. And companies, it's true that sometimes they struggle, or sometimes they think that they struggle because there's also lots of disinformation or not enough information to understand what their obligations are. Regulators sometimes struggles to coordinate, and people, which are the main beneficiaries supposedly of this regulation, often find exercising the rights unnecessarily burdensome, right? And burden has become one of the main words when it comes to this simplification. So if the objective is to make the rules clearer, easier to apply, and more coherent, that's something I think very few people would oppose, and digital rights organizations among these. But the problem is that simplification and deregulation are not the same thing, and what we have seen is, this deregulation dressed up as a simplification. So when you actually read the digital omnibus, which is true that the GDPR was already simplified, so to say, with the fourth omnibus, but that was just one article. But we already saw the intentions of the Commission and some of the insufficiencies of the process, which I might elaborate on afterwards. You see that many of the proposals are not administrative or technical. You spoke about a streamlining, right? They reopen some of the most fundamental political compromise that the European Union has reached only a few years ago, namely the AI Act, that supposedly started to apply this year, but also the GDPR and the e-privacy directive. And those are not technical clarifications, but you look at the nature of the proposal, right? They're policy choices about how much privacy, data protection, transparency, and accountability European people or people in the European Union should enjoy in an increasingly data-driven economy, because what has become more complex is not just, of course, the regulation, but also the technological or the digital ecosystem, right? One in which AI is the elephant, the big elephant in the room, maybe, but also many other technologies offer ways to handle data that have proven potentially harmful, right? And this is why we always say it's important to step back and look beyond these laws and the digital rulebook as a whole in order to understand what simplification do we need, what simplification does the EU need. Particularly, why am I saying that? Because the digital omnibus doesn't exist in isolation. It's a part of a much broader political trend that we've been seeing across the European Union over the last maybe a year, a little bit more, right? Ever since this famous or infamous Draghi report. And whether we're talking about environmental laws, corporate sustainability, AI regulation, also we've seen about finance. We have seen already 10 omnibus packages. There's an increasingly common narrative that the EU's main obstacle when it comes to economic growth is regulation itself, right? And the proposed solution is therefore to remove obligations, reduce safeguards, or postpone implementation in the name of competitiveness. That this is a really good definition of deregulation, right? This is the content, but also we have a procedural problem, right? Because when you are changing the very foundations of how the European Union applies fundamental rights and how fundamental rights operate, and again, this is not just about the digital, it's about the whole of it all, those changes shouldn't be presented as technical adjustments, right? They deserve a proper democratic debate founded on the rules that the European Union has so proudly, or at least it was proudly in the past, adopted, right? But these proposals were presented without a meaningful and a full impact assessment, without proper evidence, despite affecting, as I was saying, many of the main questions that have to do with data protection, privacy, and AI governance. They change how Article 7 and Article 8 of the Charter, but all of the articles of the Charter are implicated because data protection is about human dignity and all of the fundamental rights. And again, without impact assessment, without evidence, that's something that is really important, but also with this idea of packages, right, that are put on the table as proposals very, very fast and imposed on the democratic co-legislators as this package deal that they have to at least adopt most of it, right? This idea in Brussels that you need to accept most of these proposals. You cannot deviate too much from the Commission's proposal, even if, and this is something that I really want to emphasize, even if the Commission is already working on something that has to do with a little bit of hindsight, looking at the whole digital rulebook, right, with the digital fitness check, which is going to have a full-on impact assessment, which is not going to be a legislative proposal, but might lead to legislative proposals that follow the better regulation guidelines of the European Commission, the Parliament, and the Council. So why the need? Why this urgency? I think this is one of the most important questions, right? Because this urgency is about the moment in which the proposal was put forward, but also the urgency that the co-legislators feel, right? You need to adopt this proposal in less than a year, whereas it's very technically sophisticated and complicated, and the consequences are huge. And something that we always have said is that this idea that of move fast and break things was Meta's mantra, but also many others. I guess companies can afford that, whereas if you ask me, they couldn't. But this is the private sector, but governments cannot afford that. If you're going to change a law that protects fundamental rights, how are you going to undo that when you realize this is actually having a negative impact on fundamental rights? This is mainly it.
Although you also pointed out that the simplification efforts are broader than the digital acquis, I wanted to ask you specifically about the GDPR impact, because I think that the GDPR has been particularly targeted by the digital omnibus. So, for instance, the European Commission proposed to change the definition of personal data or to tweak the prohibition on processing sensitive data. So, can you walk us through what could happen if the digital omnibus with this packages in mind finally gets adopted as it currently stands, and what would you anticipate to happen in practice?
Thanks so much for the question. Because we have very limited time, I really want to emphasize that there's many provisions of the GDPR that are put on the table that are subject to these targeted amendments that are not targeted amendments. And actually, if you ask the Commission will keep saying, we're not proposing to change the definition of personal data. This is just a clarification or a codification of rule law. I'm going to focus on your question, which is about the definition of personal data and maybe a little bit the prohibition on processing sensitive data, or what we call in the GDPR special categories of data. But I really want to make it clear that there's other provisions and that are subject to undermining and weakening. For example, access rights, so that people can know what data the company has about them and what is being done with the data, and how important this is in order to actually strategic litigation. And why am I saying that? Because one of the trends that we've seen with the digital omnibus, and this is also materialized with the definition or with the change in definition of personal data, is that we're shifting towards self-regulation. The digital rulebook was adopted in order to prevent too much self-regulation because the companies were not behaving, most of these companies, and what we've been seeing is because the companies were not behaving and the most rules we had, some companies would behave, but some others wouldn't, and this is why enforcement was so important, but also enforcement hasn't been enough. And maybe when we ask about what simplification should look like, maybe we should be looking at better enforcement in order not to allow companies to go into this race to the bottom and invite other companies that were actually complying to say, oh, if the big companies, the worst offenders, are not going to be held accountable, then I shouldn't, right? And fair enough, we need a level playing field. And also we're seeing a shift towards putting more burden, even though all of this is made in the name of, eliminating burden, putting more burden on the people who are impacted, right? If the company doesn't have to prove something, then it's us. And again, I'm really sympathetic to companies needing to reduce the red tape, but I'm also wondering, what do we make of this idea of friction, right? when we have any kind of laws, and I'm a jurist myself, we need friction. And friction means that the company needs to worry about what's the impact of their operation, right? In this case, for example, processing of personal data. And that's not something negative, right? It means that you have to take care. The moment you reduce that friction, the company is not going to even have to think about that. But that doesn't mean that there's not going to be a negative impact, right? That doesn't mean that human rights are not going to be abused, and that doesn't mean that people are not going to be impacted. And this is when the companies don't do whatever they need to do, people are going to be the ones having to say, oh, something negative has happened, can I lodge a complaint? And this is very, very cumbersome. For people, it's almost impossible. People don't have the time, people don't have the knowledge, and even for civil society, we are already struggling with what we have to do, and now we're fighting against deregulation. So when it comes to GDPR, the definition of personal data is the entry point of GDPR. GDPR doesn't forbid companies from collecting and processing personal data. It just establishes a number of rules and principles and rights that the data subject that the people have, right? And this is why I really want to emphasize that this idea of friction, right? The moment the definition of personal data says this is not personal data, the GDPR doesn't apply. And then you have, all of these companies being able to handle data that is considered to be non-personal. And when the GDPR was adopted, right back in 2016, the law already recognized a reality, right? That it's not just about the name, and I think this is important, it's about whether the person can be identified. Most of the time we think about the names, we think about an email, but you can be targeted and you can be profiled on the internet, or communities, individuals can be profiled and singled out, and I think this is a very important term, regardless of whether there is a name. So what the GDPR did is posing a question. Can this person reasonably be identified regardless of the name? And this was okay, right? The company needed to think whether their operation or any kind of operation throughout the supply chain could, with reasonable means, identify the people could be identified. What does the proposal do? Even though the Commission says it, they don't change the definition, is that the question should be, can this particular company identify the person? And this is not the same, right? Again, we're speaking about the shift of burden. We're speaking about something that looks like a tiny legal adjustment, but it clearly isn't, especially with much more complex ecosystems. Even if a company, and there we are with the self-regulation, can say this is not personal data any longer because I have made sure that this is anonymized, and the whole debate is about pseudonymization and anonymization. If it transfers the data, and this is happening every day, every second of the day, throughout the supply chain or throughout the data broker, or to many, there's so many actors that could be recipients of this data. They also have to make sure that this data is not going to be leading to re-identification. And this is something that the EDPB recently publishing the guidelines on anonymization made that really clear, right? Even if the company says, don't worry, we can identify anyone from this information, this is not enough. You need to make sure that applying reasonable means, nobody's going to be able to do so. Companies, industry, and people defending industry have been saying that this is about an absolutist or relative interpretation of GDPR. It was always a relative interpretation. The problem was that the threshold was very high, and it was about an objective assessment and not a subjective assessment the companies would prefer, right? And where the Commission is heading at. What's going to happen, nobody knows. I think this is still going to be a red line. Even the Commission has said that in many fora, especially when you take into account that this doesn't have an impact assessment. But let's see. And I don't know if we have time for the.
Yeah, go on.
And the other part of the question actually sheds light on something that is really important for us when it comes to the digital omnibus, or in this case, the so-called data omnibus and the AI omnibus, which are the two pillars of the digital omnibus, which is the cumulative impact of it all, right? Because what the data omnibus proposes is that when so-called sensitive data, and I think all of us already understand how intimate and why this data deserves a special layer of protection, which is what the GDPR says, right? You cannot collect and process this sensitive data, which is about race, which is about sex preferences, which is about health, which is about political opinions, especially nowadays, there's a very good reason, unless you have consent or unless, the threshold is much higher, right? You cannot do that. And now the Commission says you might be able to still collect and still have this data in your database if the effort to erase this data is disproportionate. Again, we're coming back to self-regulation. It's companies reclaiming it. And also, I think we're going to speak about that afterwards, it puts at the center the need to use AI, right? Because this exemption is created just for AI. Again, disproportionate effort, what does that mean? This data most of the time should have never made it to the database, if you ask me. But this is why understanding the cumulative impact and the AI Omnibus is really important, because what the AI Omnibus does, and the AI Omnibus has already been adopted. There's no way of backtracking, saying that in order to debias a system, companies will be able to collect special categories of data-sensitive data, which they were already able to do beforehand. But you're creating a presumption, which is also one of the important one of the problems. And also, you're opting for a system or for a way of addressing bias, which is something that is integral. And there's many studies about how AI operates. That is, the more data, the merrier, right? And this is one of the mantras of the digital omnibus. The more you need more data, you need scalables, you prefer LLMs to other kinds of AI systems or models, whereas there's also many studies saying that in order to debias an AI system or model, you don't necessarily need more sensitive data, right? You need to be very careful with the database. Sometimes you even need less data, because more data might lead to more discrimination. But there you have the AI Omnibus tells companies you can get more sensitive data, and the data Omnibus says if you say it's a disproportionate effort to erase this data, maybe you can do so. And I think this explains in a nutshell how problematic this is, in order to weaken safeguards without any kind of impact assessment, and whereas the Commission keeps saying that they're keeping the same level of protection of fundamental rights.
Keeping with one of the topics that you raised within your answer, which is actually AI. So Omnibus also impacts AI in a quite substantial way, insofar as it basically targets or enables AI providers to be able to process personal data, and it expands this legitimate basis so that it can accommodate those types of use cases. So what do you think about this shift within the digital omnibus, and what do you think that the new reality is going to bring, as opposed and vis-a-vis the legal situation that these AI providers found themselves before? That was, I think, a bit legally shaky, I would say.
If that's okay with you, I'd like to challenge this premise of the question a bit, because
Correct.
It's true that industry has been saying that AI companies, or not just AI companies, I think it's any company using AI, and now we know that there's any company is forced to use AI, even if their operation doesn't have anything to do with AI, and even if the consumer has never asked for AI to be used. But it's important to say that the GDPR doesn't regulate technology. This is what we keep seeing, is technology neutral. It regulates the collection and processing of personal data. And that distinction is really important, because when cloud computing appeared, when big data, remember big data, nobody created a special cloud GDPR for social media. We don't have a social media GDPR, right? We always were okay with the fact that GDPR will regulate the principles rather than the technologies, because technologies evolved much faster than legislation. And again, as a jurist, that's completely fine. And AI is no different, right? The GDPR already allows companies to use personal data to develop AI systems. The question isn't whether they can't. The question is whether and under which conditions they can. They can use AI data, personal data, for AI training, and not just AI training. Look, this new provision speaks about AI training, development, and operations, terms that are not defined by the GDPR, for that matter. And like any other processing of personal data, collection and processing of personal data, these companies using AI, or that want to use AI, they need a legal basis, right? They need to respect a certain number of principles. If they want to use this legal basis of legitimate interest that actually allows them to gather data without asking for consent, which is something important, because they could also not asking us if we want to give them our personal data. They could. That's the principle. But if they want to use legitimate interest, and that's all of the legal bases are good enough, right? We don't have to choose amongst our children. They have to fulfill a number of criteria, right? They have to fulfill a 3-step test, and the last step will be this idea of balancing human rights. But they also have to respect data minimization. Does the AI system or model respect data minimization? Good question. They also have to respect legality or necessity. Does all of this mass web scrapping that we've seen the other day, that we're just scrapping books and burning the books, does this respect? I think this is important, and this is part of the test, and they need to respect people's rights, right? And the EDPB had already said you can do that if you fulfill the criteria. You already have an Article 6.1f of the GDPR, but companies keep pushing for that, not because they didn't have the legal certainty. I'm really sorry, because they did want to use AI maybe without respecting all of these criteria. And we've seen instances of companies using the legitimate interest, not just for AI, but for other purposes, and regulators coming to them and ask them for the legitimate interest test, and then, oof, yes, maybe in 2-3 days, maybe in 2-3 weeks, because they don't want to do the test, which they should do before any collection or processing on operation, right? That's one of the problems, right? And the second problem, again, is the technological neutrality, right? Because I can think of so many ways in which, if we allow for this carve-out, there's going to be so many demands for future carve-outs or exceptions of quantum computing, neurotechnology, synthetic biology, and also companies, again, asking for this presumption to be allowed to use AI, whereas nobody's forbidding them from using AI. They just have to use AI the same way they would use another technology. Which leads me to the third point, and it's again this need to use AI regardless of whether this is good for either the company's operation, but also for the trust of the consumer and the people in the European Union, right? I think there's already many tons of evidence that are pointing to this existence of the AI bubble, and also many studies about how AI is hurting people's rights, not just when it comes to the usage of AI, but also when it comes to the damage that it's doing to the planet. Neither the companies or the investors that are pushing for that, or the European Union, which should be the rational actor in this case, are asking themselves a question about, should we favoring AI and a specific kind of AI, as I was saying, this scalable gigafactory LLM AI. Should we favor that instead of other technologies that are more respectful of human rights, more respectful of the planet, and that also mean innovation, but another kind of innovation, right? That the European Union maybe should be championing, but apparently not, because the goal of the day is to compete against the United States and China and other actors, but mainly the United States and China, that have clearly prioritized these systems, instead of just saying what can the European Union become differentiated in. And maybe this is also the question, right? Are we able to compete against these global actors following the same specific model that they're favoring, which is when it comes to the technologies, but also when it comes to the deregulation, right?
Picking up on that last point, and as a follow-up, so zooming out of the digital regulation, specifically the digital omnibus. So according to the European Commission, the Omnibus more broadly is about cutting down on the red tape to increase European competitiveness as well, building on that report that we heard and we read from Draghi a couple of years ago. So I believe, and having read your thoughts a bit, that you oppose this narrative due to two fundamental reasons. One is that the European Commission will really not deliver on increasing competitiveness, and the second one is that the cost to get there is too high. So can you expand on that and try to frame how do you believe that this balance between simplifying or tweaking regulation and increasing competitiveness could work?
Thanks so much. So again, I don't think anybody's doubting that there's an EU competitiveness crisis. We're speaking about that for years and even decades, might I add. If you look at the reports on Europe's political economy, the diagnosis has been there for years also. We have fragmented capital markets. We have high energy costs, even higher nowadays with the war on Iran. You have difficulty scaling companies. You have access to investment. You have competing infrastructure. You have also a problem when it comes to research and attracting researchers, right? And those are structural challenges that the European Union needs to address for sure. And no matter how many footnotes of studies written by American scientists Mario Draghi includes in this report, data protection isn't going to solve them, right? Or weakening data protection, e-privacy or the AI Act is not going to solve any of those. Actually, we see that as a red herring, right? We keep promising, and it's a promise without no kind of evidence of economic growth and future or in the short and medium term, but also what kind of economic growth, because I think for years, economic growth in the European Union has been linked to this trickle-down economy, right? It's going to lead especially to the creation of jobs. Whereas when it comes to this specific kind of competitiveness or this specific kind of economic growth, does it mean more jobs? I don't think it means, because again, we're speaking about AI and the automation of work is already happening. And automation and AI is also harming workers' rights, regardless of whether they're going to lose their jobs or not, but they're also going to lose their jobs, right? So again, even if this competitiveness is real, what kind of competitiveness is this, and what is it going to mean for people in the European Union? And the second question is also, who's going to benefit, not just when it comes to the big companies, but also when it comes to which companies, right? Because again, if we make it easier to collect, combine, and reuse personal data, the biggest winners are not going to be European SMCs. Now we speak about small and medium caps, which are companies of up to 1,000 employees. Those are companies who already have enormous amounts of data, advanced AI systems. We call it data empires. Most of them are foreign. Maybe there's a few EU companies, but most of them we know are foreign. Most of them are big tech companies. So we have a real paradox, which is at the heart of the digital omnibus, right? We are promising to improve EU competitiveness, but we are actually reinforcing the market power of the very companies the EU has spent years trying to regulate through laws like the Digital Markets Act. Like, do we really want that? And it's not just about the scalability of AI, right? It's also about the legal certainty. Something that I haven't mentioned yet is with things like the definition of personal data, with things like the presumption of being able or being encouraged to use AI or personal data for AI training, operation, and development, right? Only the biggest companies are going to be able to navigate this legal uncertainty, at least when it comes to the first years. This is not a threat, but this is going to happen, right? We're going to have a number of strategic litigation cases that we had also after the GDPR, right? And it's not only now that the Court of Justice of the European Union is already settling on those. This is going to be reopened, right? We're going to have companies trying to adapt to this, right? And this is costly for these companies, right? We're going to have regulators having to adapt to this, and we're going to have civil society and the whole of the European Union. Again, it's very difficult to read into the future, but it's like 5-7 years when you look at, for example, the GDPR of a much higher degree of legal certainty. And what we hear from many small and medium companies, especially the ones that do not want to compete with Google, which is what some EU companies are already saying, right, is we have already invested enough. Maybe we didn't like the GDPR, maybe this is not the conversation, but we don't want to spend much more money trying to navigate a system that we already got acquainted with, right? And that makes really lots of sense, right? So whose companies are benefiting from that, and how is it going to benefit the people in the European Union? The two questions are really important, especially at a moment in which we're supposedly betting on European sovereignty, whatever that means. If it means self-determination, if it means less dependency, that would be great. But are we really doing that when we're weakening the laws that are mainly benefiting companies that are not held accountable, for starters?
And as a final note, a really brief question that doesn't have a brief answer, but I'm going to make it anyway. So I wanted to ask you whether there is really a version of simplification of the EU digital rulebook that you'd support, bearing in mind this conversation. So do you think that one such transformation could exist?
Sure. Again, we don't oppose simplification. I'm speaking about we, because it's not just at EDRI, it's not just digital rights organization. We're seeing trade unions, we're seeing civil society organizations represented LGBTQ rights, people with disabilities, doctors association. That was an interesting, right? Because much of it is made in the name of better health, but doctors are saying the digital omnibus might be dangerous for the patient's rights. So what we oppose is confusing simplification with lower protections, right? With deregulations. And of course, there's simplification that works, right? And there's simplification that can work hand in hand with innovation, right? First, we have guidance. And this is something that we have said also for years. All of the regulators need to be able to offer more guidance. The EDPB, or the Data Protection Supervisory Authorities, already said that they were on it with the Helsinki statement, but that applies to all regulators. But for that, what do we need? We also need more resources, because what we hear from regulators is that they are overwhelmed, not just because there's too many complaints, but because there's not enough money, there's not enough knowledge, and there's not enough competitive advantage, right? Many people would prefer going to the big companies in which they can earn much money. Then we have enforcement. We have a huge problem with enforcement. And actually, one of the reasons why EU companies are asking for weaker laws is, as I was saying before, is because the big companies are benefiting in practice from weaker laws, because they know how to navigate the system and they know how to navigate enforcement with this compliance theater. Look at the Metas, look at the Googles, how every time there's a fine, if at all, because we know when it comes to data protection, Ireland is not the best when it comes to enforcing the law. There's going to be thousands of appeals. They're not paying the fine, and they know they master the art of appealing decisions. What does that mean? European companies are receiving the fines and are paying for the fines. Big companies, especially foreign companies, are not, right? And also when it comes to enforcement, we really need to find a way to understand how regulators have to work together. This is something that actually we have in common with some companies. Companies are saying regulators need to cooperate. Actually, if you ask me, they should have a legal duty to cooperate. The DMA also was one of the perfect examples about exchange of information, right? Of course, when you respect trade secrets and you respect confidentiality, all regulators should either open cases together. The court also spoke about competition and data protection, but I think it should be broader than that. It should include content governance. It should include consumer, because this is how the digital ecosystem operates, right? It operates across laws, it operates across borders. All regulators should be invested, forced to cooperate and forced to exchange information, because opacity is also what allows companies not to be held accountable. And actually, if you ask me, the Digital Omnibus already includes one small example of actual simplification that can work for people's rights and even for some companies, which is what we call privacy signals, privacy automated signals. Cookie fatigue has been created by companies in order to collect maximum amount of data. We all hate cookie banners. Most cookie banners shouldn't be there if companies would not want to collect the data, but they want to collect the data. Okay, we have the cookie banners. We all know how they are designed. We hate them because we have to navigate, or we have to accept all. So the Commission, what they propose, it's not perfect, but it's at least started, is to centralize our privacy preference, right? Either in the browser or in the operating system, right? Just for us to be able to say once, either I want my information to be shared or my information to be processed with one specific company, not with 1,000 or tens of thousands like we see in the cookie banner. And this choice has to be respected across the whole browser ecosystem. This is simplification, right? And actually, this is simplification not just for the people, also for the regulators, and also for the companies who benefit from a level playing field. Because again, the companies who are mainly benefiting from this illegal system of cookie banners, if you ask me, because most cookie banners are illegal, are Google, are the ad tech companies, are the ones that already have all of the data and that are already abusing our rights. So again, and a good example, that doesn't mean that the Digital Omnibus is right, but a good example of simplification, respecting people's rights and creating a level playing field. That is what everybody should want, including the European Union and the European Commission.
So thank you so much, Itxaso, for that. For the audience, subscribe, like, rate the video. If you have liked the conversation, drop in the comments below anything you want. And thank you so much, Itxaso, for joining us here in the Agora.
Thanks so much, and congrats for the initiative.
Thank you. Bye-bye.